Trusts can be an instrumental tool in estate planning. They're a versatile method of achieving a variety of goals. To talk more about trusts and to address some of the myths associated with them, here's Sam Kornfeld with Keep Law.
In regard to trusts, they're a very valuable and versatile tool, and we would use those in the majority of the plans that we draft. Correspondingly, when you're planning that with folks, though, there's a lot of times that they have some myths about what a trust can and can't do. And a lot of those have to do with control, the relation to probate, what types of trusts there are, tax, and creditors. Looking at those in turn, the first myth is control. People think, well, if I have a trust, it will automatically control things, and that is not the case. The trust can only control what it actually owns. So an essential part of that plan is transferring or funding the trust so that it owns the property and can legally control it. Next up was that, well, I can eliminate probate by having a trust. And certainly that's one of the benefits, is minimizing probate, but we can't guarantee that we're necessarily going to eliminate it entirely. And that may be because some bit of property got missed, or that you inherited property after you died, which can and does happen. So any good plan is going to plan on some level of probate, even though we're going to do what we can to minimize it. People think a trust is a trust, and a trust can do anything. That is not necessarily the case. Trusts are generally hyper-specific, built to do a particular job based on your goals and your concerns. If it does one thing well, it's probably going to do other things poorly. So you need to make sure that your attorney fully understands what your goals and concerns are, so they can build that trust specifically to address those. People think, well, if I don't own it, if the trust owns my property, that's going to escape tax. The federal government taxes your estate based on what you controlled, not what you owned. So if you still controlled that trust, you will still get taxed on it. We would have to build that trust very specifically to make sure that that doesn't happen. So if that's a concern of someone, we build that trust specifically. It won't automatically avoid tax just because it's in a trust. If you have access, control, and can reach into that trust and take stuff out, a judge is likely to give a creditor who gets a judgment against you that same access. So once again, if that is a concern that someone has, we need to build that trust very specifically to prevent that creditor from being able to reach in. Creditor protection for the settlor or person who controls the trust is not automatic. Those are just a few of the myths that we dispel or deal with in an estate planning session.